This morning, federal marshals arrived at 1100 South Ocean Boulevard in Palm Beach, Florida. They didn't arrive with a search warrant. They weren't looking for classified documents. They weren't looking for evidence of a crime. They arrived with a clipboard, an appraiser, and a document known as a writ of execution. To the media, this is a circus. To the political pundits, it's a weaponization of justice. But to anyone who has actually practiced law, like I have for 30 years, what happened this morning is something entirely different. It is the boring, mechanical, and inevitable grinding of the gears of civil procedure. We are witnessing the enforcement of unpaid legal judgments totaling over $500 million. And because the debtor has refused to pay, the court has authorized the seizure of assets. One of those assets happens to be Mar-a-Lago. In this deep dive, I am going to strip away the political noise. I am going to walk you through the Enforcement of Judgments Act. I am going to explain why Mar-a-Lago's classification as a private club rather than a homestead is the fatal legal flaw that allowed this to happen. And I am going to show you why this event is actually a critical test for the American legal system itself. If a court order can be ignored by the powerful, the law means nothing. If a court order can be enforced even against a former president, the law means everything. Let's look at the evidence. To understand why marshals are at the gate today, you have to understand the timeline of defiance that preceded it. The legal system is designed with patience, but it is not designed with infinite patience. Let's review the 3 strikes that led to this enforcement action. Strike 1, the E. Jean Carroll defamation verdict. A federal jury awarded $83.3 million in damages. The judgment was entered. The statutory 30-day window to post a bond or pay the judgment opened. Instead of payment, we saw public defiance. We saw attacks on the judge. We saw delays. Eventually, a bond was posted, but the pattern was set: fight the process, not just the case. Strike 2, the New York fraud judgment. Judge Arthur Engoron ruled that the Trump Organization had engaged in persistent fraud by inflating asset values. The penalty? $355 million, plus interest. The total approached $454 million. This was a disgorgement of ill-gotten gains. The court ordered payment. The debtor claimed an inability to secure a bond of that size. This was a critical moment. When you tell a court I cannot pay, you are inviting the court to look at your assets and say, then we will take this instead. Strike 3, the second defamation judgment. In the legal world, a judgment is not a suggestion. It is a debt. It is no different than a credit card debt, a mortgage default, or a business invoice. When a debt is finalized by a court, it becomes a judgment lien. This lien attaches to your property. It follows you, and if you refuse to satisfy it, the creditor has the right to activate the nuclear option of civil law. The writ of execution. Let's get technical. What exactly did the marshals serve this morning? A writ of execution is a court order that commands a sheriff or federal marshal to levy upon the property of a judgment debtor. Levy is a fancy legal word for seize. Here is the step-by-step mechanics of how this works for anyone, whether you are a plumber or a president. Step 1, asset discovery. Before you can seize anything, you have to find it. Attorneys for the plaintiffs conducted post-judgment discovery. They subpoenaed bank records. They looked at property deeds. They were looking for non-exempt assets. Assets that are liquid, valuable, and legally accessible. Step 2, the Homestead Exception, and why it failed here. This is the most misunderstood part of the Mar-a-Lago saga. Florida has a very strong Homestead Exemption. Article X, Section 4 of the Florida Constitution protects your primary residence from forced sale by creditors. If Mar-a-Lago were just a house, the marshals could not touch it. But Mar-a-Lago is not a house. In 1993, Donald Trump signed an agreement with the town of Palm Beach to convert the private residence into a private club. That agreement legally redefined the property. It generates income. It has members who pay dues. It has a commercial kitchen. Legally, it is a business asset. Business assets do not get homestead protection. This was the strategic error that exposed the property. By turning his home into a business to make money, he stripped it of the legal armor that would have protected it from seizure. Step 3, the order to seize. The plaintiffs presented this evidence to a judge in the Southern District of Florida, domesticating the New York judgment. The judge agreed, the property is commercial. The debt is valid. The debtor has refused to pay. The writ was issued. Step 4. The physical seizure. That brings us to today. When marshals seize a property, they don't necessarily kick everyone out immediately. They enter the property. They serve the papers. They take constructive possession. This means the locks might change, or a court-appointed receiver is placed in charge of the operations. From this moment on, the revenue from the club, the membership fees, the wedding bookings, the restaurant tabs, no longer goes to the Trump organization. It goes into an escrow account controlled by the court to pay off the debt. There is a supreme irony in this seizure. The fraud case that led to the $355 million judgment was based on the finding that Donald Trump inflated the value of his assets to get loans, and deflated them to lower taxes. Now, the court has to determine the actual value of Mar-a-Lago to sell it. If the property goes to auction, the market will decide the price. And here is the trap. Donald Trump has claimed Mar-a-Lago is worth $1 billion or even $1.5 billion. Real estate experts and tax assessors have pegged it closer to $18 million to $27 million based on its restricted use as a club. Scenario A. If it sells for $1 billion, the debt is paid, and Trump gets the change. But if it sells for $1 billion, he likely owes hundreds of millions in capital gains taxes, and it proves the tax assessor was undercharging him for decades. Scenario B. If it sells for $50 million, the realistic market value for a club with deed restrictions, it doesn't even cover 10% of the debt. He loses the property, and he still owes $500 million. The seizure forces a mark-to-market event. The fantasy valuations are over. The real numbers are about to be written on a check. Why should you care about a billionaire losing a golf club? Because this is a stress test for the American experiment. The fundamental promise of the rule of law is equal application. If you or I refuse to pay a court judgment, our wages would be garnished. Our car would be repossessed. Our bank accounts would be frozen. For a long time, there has been a perception that if you are rich enough, you can delay justice until it is denied. You can appeal forever. You can hide assets in shell companies. You can intimidate plaintiffs. This seizure is the system saying, no. It is the system saying that a judgment is a judgment. It effectively pierces the veil of invincibility that surrounds ultra-wealthy defendants. If the marshals had backed down, if the judge had said, well, it's too politically sensitive, let's not enforce the writ, then we would have officially created a two-tiered justice system. We would have admitted that the law applies to the poor, but is merely a suggestion for the powerful. By enforcing this writ, the judiciary is asserting its supremacy over politics. A jury verdict is not a political opinion poll. It is a fact. A debt is not a negotiation. It is a math problem. The seizure of Mar-a-Lago is the system doing exactly what it was designed to do, enforce contracts and judgments without fear or favor. We are already hearing the spin. This is election interference. This is communism. They are stealing my house. Let's dismantle that with legal facts. Fact 1. Due process was afforded. Donald Trump had months of trials. He had lawyers. He presented evidence. He cross-examined witnesses. He lost. He appealed. He lost appeals on the bond issue. This seizure is occurring at the end of a very long, very fair road. It is not a sudden, midnight raid. It is the caboose of a long train of due process. Fact 2. Seizure is not theft. Theft is taking property without legal right. Seizure is taking property with legal right to satisfy a debt. If the bank forecloses on your house because you didn't pay the mortgage, they aren't stealing it. They are exercising their lien. The plaintiffs in these cases are essentially the bank now. They hold the lien. Fact 3. It's reversible, with money. There is one way to stop this seizure instantly. Write the check. If Donald Trump wires $600 million to the court registry today, the marshals leave. The writ is dissolved. The property is his again. The fact that he hasn't done this suggests a simple truth: liquidity crisis. Assets on paper are not cash in a bank. You can be a billionaire in real estate and still be broke when the bill comes due. This seizure exposes the difference between net worth and cash flow. So, the marshals are there. What is the timeline? Phase 1, Inventory and Appraisal, current phase. The court-appointed receiver is currently inventorying the property. Does the seizure include the furniture? The art on the walls? The chandeliers? Yes. Unless they are personally owned items exempt from the levy, everything owned by the club entity is fair game. Appraisers are walking through the ballrooms right now, putting price tags on the legacy. Phase 2, the auction announcement. The marshals will schedule a public auction. Sheriff sale at 1100 South Ocean Boulevard. It will be listed in the legal notices section of the newspaper. Qualified bidders will have to put up deposits. Phase 3, the sale. This will be the media event of the century. Bidders could include hotel chains, private equity firms, or other billionaires who want a trophy property. There is a non-zero chance that a political supporter could buy it and lease it back to Trump. Or, a political opponent could buy it and turn it into a public park or a condo complex. The law doesn't care who buys it. It only cares that the check clears. Phase 4, distribution. The auction hammer falls. Let's say it sells for $400 million. The marshals take their fee, usually a percentage. The outstanding mortgages on the property are paid first. Then, Jean Carroll gets her $83 million. Then, the state of New York gets its fraud judgment. If the money runs out before the debts are paid, the marshals go to the next property. Trump Tower? Bedminster? The private jet? The writ of execution is a hungry ghost. It eats until it is full. This is a sobering moment. It is easy to get caught up in the schadenfreude or the outrage. But I want you to look at this through the lens of a citizen. We rely on the civil courts to keep society functioning. If a contractor rips you off, you sue. If a driver hits your car, you sue. If a company poisons your water, you sue. We trust that if we win, the system will make us whole. Today, we saw that system work under the highest pressure imaginable. We saw that a piece of paper signed by a judge is more powerful than a private jet, a Secret Service detail, or a brand name. We saw that in America, eventually, the bill comes due. The seizure of Mar-a-Lago isn't the end of Donald Trump. He has other assets. He has political power. But it is the end of the illusion that he is immune to the basic mechanics of the law. The marshals are at the door. The inventory has begun. The law is working. If you want to track the legal filings, the appraisal numbers, and the auction date as they are released, make sure you are subscribed. I will be breaking down every motion and every appeal in real time. This isn't politics. This is procedure. And procedure just walked through the front gate.